Good afternoon. Welcome to Football Counsel. I am Luis Núñez, and today we're going to talk about FIFA's Football Tribunal. And for that purpose, I'm accompanied by Dr. Pablo Obrera, who is a specialist in football law and also the president and founder of Derechos del Fútbol and Football Counsel. Also, as usual, we are here with the help of our friend and IT expert, Daniel Ortregas, for any problems that we might have regarding the use of the platform. So that being said, let's dive right into our topic. For today, we have prepared, again, some preliminary considerations in regards to the Football Tribunal as follows. The Football Tribunal was implemented on October 1st, 2021 to consolidate the existing FIFA decision-making bodies into a single umbrella body. Those decision-making bodies were namely the Player Status Committee and the Dispute Resolution Chamber. The Football Tribunal is part of FIFA's ongoing commitment towards the modernizing of football regulatory framework and, more importantly, the FIFA dispute resolution system. So where's the legal basis? Pursuant to Article 1, Paragraph 2 of the procedural rules governing the Football Tribunal is composed of three chambers: the Dispute Resolution Chamber, or DRC, the Players Status Chamber, formerly named the Player Status Committee, or PSC, and the newly created Agents Chamber, or AC. So that being said, let's dive into the Dispute Resolution Chamber organization. The DRC is composed of one chairperson and two deputy chairpersons, 15 player representatives, and 15 club representatives. As you can see, the same amount of representatives from clubs and players are there. That's to comply with FIFA's demand of complying with the parity principle. That is to say, the same amount of representatives from the players and the same amount of representatives from the club have to be in the chamber, right? That's also an obligation for national dispute resolution chambers that attend to labor disputes. They have to comply, among other guidelines set out by FIFA, with the parity principle. So if it's not, the parity principle is not contained in that chamber, dispute resolution chamber, it won't be recognized by FIFA. That is the most important thing to understand here in regards to labor matters. So then we got the dispute resolution chamber jurisdiction. What type of disputes it decides? So according to Article 22, Paragraph 1, A, B, D, E, and F, and Article 23, Paragraph 1 of the regulations on the status and transfer of players, hereinafter RSTP, the DRC is competent to hear disputes between clubs and players in relation to the maintenance of contractual stability where there has been an ITC request and a claim from an interested party in relation to said ITC request, in particular three things: regarding the issue of the ITC, sporting sanctions, or compensation for breach of contract. This is very, very important for one of the leading cases we have chosen, and we will see furthermore. Also, employment-related disputes between a club and a player of an international dimension. It has to be with an international dimension, and we'll go further into it. Furthermore, disputes relating to training compensation and solidarity mechanism between clubs belonging to different associations that are not governed by the FIFA clearinghouse regulations. This is very interesting, what is coming up next. So we have disputes relating to training compensations and solidarity mechanism also, but between clubs belonging to the same association, provided that the transfer of a player at the basis of the dispute occurs between clubs belonging to different associations that are not governed by FIFA clearinghouse regulations. Okay, let's stop here. This sounds as confusing in Spanish as it does in English. So what this means, this is a classic example between a transfer of Club A in one association to Club B in another association. That transfer of that player, the dispute arises from a club that formerly trained that player, for instance, and it was in the same association as the club of origin. So you can see the club of origin, the training club, and the club of destination are from different associations, but this club is further down the chain of clubs previously training the player. So in instance, in resuming, this club that it was the training club has probably training compensation rights or solidarity mechanism rights that can ask from the engaging club. So that's basically that dispute matter that is set in that part. Okay. Also, is matters of legal or factual complexity in an electronic player passport review process in accordance with Article 10, Paragraph 3 of the FIFA Clearinghouse Regulations, and dispute between clubs in accordance with Article 18, Paragraph 2 of the FIFA Clearinghouse Regulations. There's a very important detail in regards to solidarity mechanism and the electronic player passport review process. And it's the fact that disputes related to training compensation and the solidarity mechanism are processed exclusively via transfer matching system. Equally, the electronic player passport review process per the FIFA Clearinghouse regulations is conducted entirely in the TMS also. So the DRC shall not hear any case subject to the FIFA regulations if more than 2 years have elapsed since the event giving rise to the dispute. The application of this time limit shall be examined ex officio in each individual case. This means that the chamber is part of the chamber's obligation to examine if the time bar, the 2 years have elapsed or not. So there's no need for a party to require that. Again, it's the obligation of the chamber to, first of all, verify that the 2 years haven't passed. Again, now we're going to talk about the player status chamber. Okay, its organization. The PSC is composed of one chairperson, a deputy chairperson, and the necessary number of members as decided by the FIFA Council. These members are proposed by member associations, confederations, players, clubs, and leagues. In regards to its jurisdiction, according to Article 22, Paragraph 1, C and G, and Article 23, Paragraph 2 of the RSTP, the PSC is competent to hear contractual disputes between a club or an association and a coach of an international dimension. Also, disputes between clubs belonging to different associations. Also, the PSC is competent to hear international transfer certificate disputes, validation exceptions for international transfer certificates, application for registration of minors, eligibility decisions. That's if a player is eligible to play for a certain team of a member association, for example, and also changes of a player from one association to another. Again, as well as in the DRC, the PSC shall not hear any case subject to FIFA regulations if more than 2 years have elapsed since the event giving rise to the dispute. Application of this time limit shall be examined again ex officio in each individual case. Okay, now we're going to go about the agent chambers organization. The AC is composed of one chairperson, one deputy chairperson, and the necessary number of members as decided by the FIFA Council. In regards to its jurisdiction, the basis of the legal basis for this is Article 20, but of the FIFA Football Agent Regulation, not the RSTP. And that article states that without prejudice to the right of a football agent or a client to seek redress before an ordinary court of law, the agent chamber of the Football Tribunal has jurisdiction to determine disputes arising out of or in connection with a representation agreement, again, with an international dimension, where a claim is lodged in accordance with the procedural rules governing the Football Tribunal, and again, no more than 2 years have elapsed from the event giving rise to the dispute. The application of this time limit shall also be examined ex officio in each case by the agent chamber. So all the decisions issued by each of the chambers of the Football Tribunal can be appealed to the Court of Arbitration for Sports. Said appeal must be lodged within 25 days of notification of the grounds of the decision, because if we don't have the grounds, we don't have the reasons and the arguments to appeal. That's basically the reason. So it's when we got the grounds, we're notified of the grounds of the decision that the 21 days start running. Okay, so we are coming now to the fun part, the leading cases. We have chosen a couple of topics that we think are of interest in regards to awards issued by CAS. And again, you can further inquiry and study more of these awards from the CAS and Football Annual Report for 2023, published by FIFA, and that is also posted in their website. So the first topic that we chose was standing to sue or be sued. That is the right to a body to, in this case, appeal before CAS, and the counterparty to be summoned to participate in CAS proceedings. So we have chosen to that purpose CAS award identified as 2021-8-7757 and 7762, CF Pachuca and Cristian Cueva versus Santos FC and FIFA. So in this case, the standing of FIFA to be sued was analyzed. The case is rooted in a FIFA DRC decision ordering the player Cristian Cueva to pay compensation to his former club Santos FC for terminating his contract without just cause. Moreover, the player's new club Pachuca was also held jointly and severally liable for the amounts owed to Santos SC. Cristian Cueva and Pachuca appealed the decision to CAS and summoned FIFA. FIFA stated that this was a horizontal dispute and therefore had no standing to be sued. When FIFA tells this, in other words, when the chambers issued their decisions, it wasn't on the basis of the disciplinary powers of FIFA, for example. That would make the dispute vertical. Basically, what he's saying, this is a dispute between two parties, and we're just deciding, so you should not summon us to the proceedings. But CAS thinks otherwise, right? So the panel referred to Article 75 of the Swiss Civil Code and held that the very fact that a resolution decision issued by a FIFA body would be set aside or modified by CAS confers sufficient legal interest to FIFA to be summoned by an appellant. This is very important. So regardless, in this award, regardless of the horizontal, vertical nature of the dispute, FIFA can be summoned because it has legal interest, sufficient legal interest. And one of the findings of the panel was that any association, by definition, has in principle a legal interest in preserving its own decisions in order to keep its regulatory system as shaped and interpreted by its own organs and deciding bodies. When FIFA, furthermore, says the panel, is not interested in defending the decision adopted by its own body, it may simply decide not to take part in the CAS proceedings and not to exert its rights as a party to the case, but it will certainly not lose its standing to be sued. It can be summoned. The panel entered into the merits of the case and lowered the amounts owed to Santos FC under the DRC decision, so the appeal was partially upheld. We're going to see through the different cases that this happens quite often, that the appeal is partially upheld, but basically for CAS to modify the compensations owed to one of the parties. That's basically when it's partially upheld. It's usually because of this. So now we got the topic being issue here is about jurisdiction. For that, we have chosen CAS award identified as 2021-8-7865 Alexander Paulavets versus FC Dinamo Brest and FIFA. The player filed a claim in front of the DRC requesting compensation for breach of contract and that the decision previously issued by the National Dispute Resolution Chamber be annulled. The DRC had declared the claim of the claimant inadmissible due to the lack of international dimension, as both parties were from Belarus. Remember that for the chamber to be competent, it has to have the dispute, it has to have an international dimension. We're going to see more about this. The player then lodged an appeal to CAS arguing that the DRC was competent on the basis of Article 21(1)(a) of the RSTP that we probably previously read. The view was not accepted by the sole arbitrator, who agreed with FIFA, and this is very important. This is more important part of the award, that an ITC request in itself does not cure the lack of international dimension required for the DRC to assume jurisdiction. So the ITC by itself, it doesn't confer the dispute an international dimension. An ITC does not supersede also the applicable domestic regulation that will prevail, or even the perceived ambiguity in the interpretation of the regulations of the National Association, so as to provide the necessary international element to activate FIFA's jurisdiction. That's very important. The appeal was therefore dismissed by the sole arbitrator. We got now two cases regarding the validity, one of a contract, and the second one we're going to see after this one of a clause. So we had chosen a case award identified as 2021-8-8303 Persatuan Bolasepac Negeri Johor versus Mr. Camilo da Silva Zambeso and Mazatlan Football Club. This award was issued on September 7, 2023. The issue centered on the pre-contract signed between Persatuan and the player. Following the signing of the pre-contract, the player entered into a permanent contract with the Mexican club Mazatlan FC. In particular, the player's decision was prompted by Persatuan's failure to contact him to undertake a medical examination, a prerequisite that conditioned the validity of the pre-contract, which would automatically be converted into a definitive contract between the two parties if complied with. Persatuan lodged a complaint with the DRC seeking compensation for the player's breach of contract. However, the claim was rejected and the club was ordered to pay an amount based on the provisions of the pre-contract. This decision was in turn appealed to CAS by Persatuan, which requested that the player and the Mexican club be held jointly liable for the breach of contract. In response, the player stated that the pre-contract was not valid and binding, asserting that he was not liable for breach. He was stating that the pre-contract was not valid and binding. That never sounds good when you execute a contract. And let's see what the panel says. Well, it's a sole arbitrator, sorry. The sole arbitrator firstly assessed and concluded that the pre-contract was indeed a valid and binding contract, and its conversion into a definite contract depended on two requirements, namely, one, the player passing the medical examination, and two, being transferred to Persatuan without a transfer fee. This is the most important part. Pursuant to Swiss law, a condition is deemed fulfilled when one of the parties prevents its fulfillment by acting in bad faith. The sole arbitrator found that the player actually acted in bad faith, and as a result, the first condition was deemed to be fulfilled. The first condition was the player passing the medical examination. It seems like he didn't want to do that. So consequently, the second condition was also met as the player's former club had waived its right to receive any amount for the transfer of the player to Persatuan. Consequently, the sole arbitrator considered that the conditions included in the pre-contract had been fulfilled and found that the player had breached the said pre-contract without just cause by signing with the Mexican club, thereby preventing the parties from entering the definite contract. As a result, Persatuan was entitled to receive compensation. It's important, which was calculated based on the total value of the player's contract with the Mexican club, reduced by the salary saved by Persatuan due to the termination. The appeal was therefore partially upheld. That's a way of calculating compensation. There are other ways. So the second example we got in regards to the validity, in this case, of a clause is in the case award identified as 2023-A-9441 Santos Football Club versus Fabián Daniel Bustos. Excuse me. ¿Alguna pregunta, Dani, hasta ahora? No? Okay, I continue.
Ninguna pregunta, perdón.
Okay, so the parties signed an employment contract and 2 image rights agreements in February 2022. Those contracts allow the early termination by either party. Due to the poor results, the club terminated the contract in July 2022. The coach then lodged a claim before the players' status chamber, which was accepted, determining that the club terminated the contract without just cause. Before CAS, the club argued that the employment contract and image right allowed termination without compensation. The club asserted that the termination was legally valid and that the coach, listen guys, received compensation under Brazilian labor law. This is a national law, imperative at that. Furthermore, the club contested that the PSC decision and argued for the supremacy of Brazilian law, rejecting the need for written notice or in the contract. Additionally, the club sought a reduction or dismissal of compensation claims and presented the coach new contract with Barcelona Sporting Club for consideration. This is very smart on the part of the club because if it's found liable by the award issued by CAS, they are going to limit or at least the compensation that is going to be liable to pay is going to be lower because they're going to show that the coach had a new contract and they usually deduct that circumstance from the total amount to be paid. So it's very much suggested as a best practice. Okay, regarding the applicable law, the panel invoked the hierarchical structure outlined in Rule 58 of the CAS Code, placing the FIFA regulations at the forefront. Despite the explicit choice of Brazilian law by the parties, and they're going to explain why. The panel determined that the CAS Code hierarchy favored the application of FIFA regulations and Swiss law, emphasizing the significance of Lex Sportiva in ensuring uniformity and equality in global football disputes. It's very important that they had used as a basis for the application of FIFA regulations as Swiss law, not only the CAS Code, but also Lex Sportiva due to the necessity to have predictable and somewhat predictable dispute resolution systems so that it be uniform and equal to all parties as much as can be expected. Subsequently, the panel analyzed the validity of the contract clause, allowing termination without just clause. And this is the conclusion they came. Despite acknowledging the parties' freedom to negotiate, the panel assessed the clause under Article 6 of Annex 2 of the RSTP and Swiss law again, finding it lacked proportionality and created an imbalance by reducing compensation to zero, contrary to the mandatory nature of applicable regulation. In other words, it seems like the appreciation of the panel is that the club was trying to circumvent the applicable mandatory regulations of the RSTP. The panel rejected the validity of this clause, deeming it null and void. It's very important. It's a null and void clause. The panel addressed then whether the club terminated the contract and the image rights agreements without just cause. Considering the FIFA regulations and Swiss law again, the panel found no just cause for termination, highlighting the club's decision based on sporting performance as potestative and a threat to contract stability, because it led to the will of only one of the parties, the validity and or termination of the contract. Consequently, the panel calculated the compensation considering the coach's mitigation of damages and reducing the compensation accordingly. Again, because the club was able to present the new contract of the coach, it helped mitigate the amount that was to be paid in compensation to the player. Let's go to another topic. We're going to talk about a mutual termination of employment contract. One would say, well, it was a mutually terminated contract, there should be no problem. Okay, think again. We have chosen CAS Award 2021-8-8469, Al-Shabaab Football Club versus Jedrius Arlaukis. This award was issued on February 6, 2023. The dispute was related to a termination agreement between the parties. In particular, since the club did not meet the deadline for fulfilling its financial obligation to the player, the latter considered that the acceleration clause included in the aforementioned contract, that is to say, the termination agreement, not the labor contract, had been triggered and therefore requested to be paid the full outstanding amount. The claim was accepted by the DRC, and following the notification of the decision, the club appealed to CAS. The sole arbitrator concluded that the deadline provided, again, in the termination agreement had not been respected by the club, so the player was entitled to receive the full amount foreseen in the termination agreement in view of the acceleration clause. Moreover, the sole arbitrator found that there was no duty for the player to mitigate the damages, that would be the general way to proceed, since both parties deviated from that obligation via the relevant clause in the termination agreement, not the labor. As a result, the appeal was dismissed. So I think the most important idea that we can take from this award is the fact that if we sign a termination agreement, again, to terminate a labor contract, for lack of better English, right? The terms and conditions set out in that termination agreement are the ones that are going to govern the relation between the parties. So it's very important that we have very much in detail, when are we going to get paid? What are the consequences? And in this case, both parties waive the obligation to mitigate damages. So we can put whatever we want, provided it's legal or under the regulations, but it's important that we be very clear on what we want, because that termination agreement can also be breached, like it happened here. So we're talking now, this is one of my favorite topics, not because I want contracts to be terminated early, it's because there's a lot of particularities and each one is different from the other sometimes, you know? So the topic is early termination of employment contracts. We have chosen for this purpose CAS award identified as 2022-8-8972, pardon my French, Toussaint Mazembe versus Isaac Amoa and FIFA. Initially, the player was loaned to Encana FC, a second club, by Mazembe, and entered into a contract with the club until June 30, 2021. Encana terminated the contract without just cause in February 2021, leading to discussions between the player and Mazembe regarding his return to the club. Disputes arose due to Mazembe's lack of interest in the player's return, ultimately resulting in the contract termination by the player. Subsequently, the player lodged a claim before the DRC, which was partially accepted, ordering Mazembe to compensate him with the amount of $251,666 for the breach of contract. Sporting sanctions were also imposed on Mazembe under Article 17 of the RSTP due to the breach occurring during the protected period. Sporting sanction. So before CAS, Mazembe argued that the player breached the contract by being absent without cause. The club contended that even if the player had just cause to terminate the contract, the compensation awarded by the DRC was excessive, seeking a reduction. Additionally, Mazembe disputed the justification for foreign sanctions, citing potential harm. The panel determined that while the player actively attempted to engage Mazembe regarding his return and visa requirements, the club had failed to secure a visa or provide support. Consequently, the panel concluded that it was Mazembe's responsibility to obtain a valid visa on time for the player, and its failure was considered just cause for the termination by the player. Furthermore, it emphasized that the absence of prior default notice from the player was not deemed an absolute necessity in the context of this case. It's usually the case when you are asking for outstanding monies. Subsequently, the panel calculated the amount of compensation using the residual value of the player's contract, meaning the period from July 1st, 2021, that's the expiry date of the loan contract, to Mazembe contract expiry date, and that would be the compensation for the player. Lastly, I'm thinking it's less than what the DRC gave. Lastly, the panel confirmed the sporting sanctions despite Mazembe's objections. As a result, the appeal was partially upheld, and the appeal decision was slightly amended. There it is on the financial compensation. Continue. No hay preguntas, Dani. No questions.
En el comentario te dejé uno.
No lo veo. Ajá, ahí soy. Okay. Okay, there is a question here. Did the club respect the termination agreement's deadline? No, that's exactly the point. They didn't pay on time, so the panel decided that you didn't have to put the full give the full notice to the club. Since the time elapsed and they didn't pay, that triggered the acceleration clause, and the club was obliged to pay. I don't know if that answered the question. If not, please ask me again. I'll gladly answer it. So we're going to talk about penalty clauses. Okay. For that purpose, we have chosen case award identified as 2021-8-8365 Torino Football Club SPA versus Club Atlético Osasuna. This award was issued on February 28, 2022. Very interesting. This for me is one of the most interesting ones today. The case focused on a contractual penalty clause agreed upon by these clubs in case a specific player will be transferred from Torino FC to the Spanish rival Athletic Club Bilbao. Of course, the player eventually moved to Athletic Club Bilbao, and Torino FC was ordered to pay the relevant penalty fee to Club Atlético Osasuna. Torino FC contested this decision in case and claimed inter alia that the penalty clause was in breach of Article 18 bis of the RSTP and should therefore be regarded as an illegal clause. Let's remind that the Article 18 bis of the RSTP is the one pertaining to third-party influence, which we all know is prohibited by FIFA. In deciding this issue, the panel left the question open as to whether the clause was a TPI clause and concluded that in any event, the answer to this question will not result in the clause being null and void per se. Important, it further develops the idea. The panel noted that the FIFA regulations do not contain a provision governing the invalidity or enforceability of a contract clause that is in violation of Article 18 bis of the RSTP. In the panel's view, this clearly indicated that FIFA had not intended to regulate this matter, and the only consequence of violating this provision is a disciplinary one. The panel further noted that the clause was agreed in accordance with the principles of contractual freedom and pacta sunt servanda, so that the appeal was dismissed. So, in other words, okay, FIFA, we can see the legality of if FIFA includes any article concerning the invalidity or enforceability of a contract clause that is in violation of the Article 18 bis. We don't have that in place right now. But today, what this award translates to is maybe in the future, Osasuna could be found liable for breaching the TPI regulations, and that would make him subject to a disciplinary sanction, probably. But in any case, in this case, Torino has the obligation to pay Osasuna the penalties because we sports lawyers are not in a different world from the rule of law, and we have to honor what is being agreed upon by the parties. You know, it's different when you try to circumvent mandatory regulations. In this case, pacta sunt servanda, the contracts must be complied with, and we have freedom to contract. So that's basically the situation there. So this is the last topic that we chose for today. We're going to do this exercise maybe in further detail with less cases in the future, but I put it at the end because this one is very famous. So it's about clearing house and the solidarity mechanism. So the award is a CAS award identified as 2021-8-8543 Paris Saint-Germain Football versus Football Club Barcelona. Award issued on April 12, 2023. The main issues for the panel to resolve were: one, whether the transfer of footballer Neymar from FC Barcelona to PSG was to be qualified as a transfer in the context of the RSTP regulations, and secondly, whether solidarity contribution was due to Football Club Barcelona. For the first question, the panel had to assess the nature of the relevant clauses included in Neymar's contract with Barcelona. That is to say, whether they should regard the clause as a liquidated damages clause or a buyout clause. And the consequences, the legal consequences, are very different. We're going to see. In this respect, the panel found that the relevant clauses had to be regarded as a buyout clause, and saw the main importance in the fact that Football Club Barcelona was required to release the player's ITC in case the amount stipulated in the clause was paid, and that it would not request the imposition of any sporting sanctions on the player. So this is very important when drafting a contract with a buyout clause. We should put the obligation of the releasing club to issue the ITC, right? And when the payment is due in full, or not even that, it wanna refuse it, and also that it would not request imposition of any sporting sanctions on the player. That would be the best practice there. So moreover, the panel noted that the terminology of the relevant clause was rather consensual and established the preconditions under which the player would exercise its right rather than determining the consequences in case of a breach of contract. So basically, in other words, if we put a buyout clause and the player or the club, if it's allowed a third party to pay, if we comply with the payment, we are entitled to the issuing of the ICT and also the not soliciting of sanctions. So also it's very important that we understand the nature of each of these clauses. That this is the idea I wanted to share with you. When we comply with the terms of condition of the buyout clause, we're complying with the agreement. That is very different when there's a liquidated damages clause that is triggered when I breach the contract, and that's the penalty or the indemnity clause that I should pay to the non-breaching party. So the panel then analyzed whether the solidarity contribution mechanism applied to buyout clauses and noted that a buyout fee is not materially different from a negotiated transfer fee for the purposes of solidarity compensation. Apart from that, the panel emphasized that it deemed the transfer consensual, as FC Barcelona never objected to the issuance of the ITC, nor was there any objection from its side. Finally, the panel noted that PSG itself had considered the transaction to be a transfer because it had declared the incorporation of the player as a transfer to the relevant national tax authority. Gotcha. There it is. In view of the above, the panel concluded that there were no further arguments for denying payment of solidarity contribution by PSG to FC Barcelona and dismissed the appeal. So that's our presentation for today, our discussion topics. We want to take the opportunity to, if there's not any question, of course, seems like there's none. We want to take the opportunity to express our gratitude for supporting the channel, and also with that we are very eager to see you once again in our next live session that we're going to announce in due time through internet and our social media accounts. So until then, guys, be safe. See you soon.